Okay, Ms. Jordan Byron, Ms. Tabachnik,
Here.
Mr. Cantor, Ms. Lingalis,
Here.
Mr. Bryce,
Here.
Ms. Wells,
Here.
Ms. Linkowski,
Here.
Mr. Schulman. Sorry, I went a little out of order.
Here, and you left out Attorney Rowena.
Oh, sorry about that, Mr. Rowena.
Here. Thank you, Louis.
Okay, now we want to go into the training session. Do we need a motion to go into the training session?
Nope.
Okay, so we just will go into the training session. And I'll turn it over to our trainers, whichever attorney is going to start.
Great. Brian, I don't see an option to share my screen. I don't know if that's my app or.
It should be at the bottom. Do you don't see the green button, Matt? And Mario, I saw
there
you
it is.
trying to talk
Yep,
to
I
Lee.
do see it. I do see it now. Yes. Okay. Thank you.
And Mario, we can't hear you. Yeah, check your mic thing, Mario, at the bottom. Make sure you're on the right one.
Mr. Williams just arrived, so.
Full house.
Still a little small for me.
You
Much
should
better.
be able to zoom in on your computer as
That's
well.
better. That's good. I can actually read it. I don't know about others, but
And Mario, we still can't hear you.
We might be able to get you a call-in number if you need that. Is there a phone number maybe you could call in, Brian?
Yeah. I'll send that to Mario.
Are you able to hear me now?
Yes.
There you are.
Thank
Yeah.
you. Sorry about that. So, good evening, everyone. Mario Coppola, Corporation Counsel, and I'm here this evening with my law partner, Nick Pamonte, who's a partner at my law firm, Birch & Moses, as well as Matt Sapienza, who is, as most of you know, or all of you know, our Assistant Corporation Counsel. So thank you for having us this evening to provide training for you. It's something that we have tried to do in the past. We have not always done it as often as we'd like to, and going forward, we hope to provide this training session once a year, or at a minimum once every 2 years. And one reason to do so is there's a requirement for training. So at a minimum every 4 years, or during each commissioner's term. So for the Planning and Zoning Commission, I believe you have a 3-year term. Is that correct?
I believe so.
Is that correct, Ms. Chairman? Ms. Chairwoman? I think you have a 3-year term, correct?
I believe so.
And so within each of your terms, so every 3 years, you're required to have training. And the training is for a minimum of 4 hours. And the training has to consist of any number of topics, from affordable housing and fair housing policies to process and procedural matters, training for FOIA, our Freedom of Information Act, and other aspects of the work that you do. This particular orientation session, we believe qualifies under the statute as part of your required training. So the Connecticut Office of Policy and Management is not issuing certificates for training programs saying which ones are qualified under the statute. It's basically kind of on an honor system right now, to some extent similar to what the attorneys have for their requirements for training. So I suggest that all of you keep track on your own. So during each term, just, keep a folder of when you do training and keep a record of that. And to the extent possible, the department could try to help each of you with keeping a record for any training sessions which you do through the Planning and Zoning Department, such as this orientation they could certainly keep track of this one. But if you attend something else and they're not aware of it, obviously they can't keep track of it.
Mario, can I ask a question about what you have up on the screen?
Sure.
The second exception does not apply to a Connecticut barred attorney or zoning enforcement officer with 4 or more years of experience on such board or commission. What is a zoning enforcement officer?
It would be, as titled, someone who's a ZEO, probably a member of Casio. I think most zoning officials could qualify as a zoning enforcement officer because most zoning officials, when I say zoning officials, I'm sorry, most zoning staff, most members of a planning and zoning department would probably qualify as a zoning enforcement official because at some point they're doing some work in the zoning enforcement area. But I would ask that if anyone is on our P&Z commission or ZBA and they happen to work in another planning and zoning department and they want to know whether they qualify, just let me know and we could talk about what their role is, where they work, and see if they qualify.
Thank you for the clarification.
Yeah, and by the way, I don't know why attorneys are in there. I mean, because someone's attorney doesn't mean that they have any better knowledge of the rules and regulations that statutes that that you should be aware of for the work that you do. Certainly, there's a lot of land use practitioners who are on boards and commissions that would maybe have the requisite knowledge, but for some reason, after the legislation was enacted, at some point there was an amendment that provided for this exception for a zoning enforcement officer. And that probably should be expanded, as Lou, as you pointed out, to probably anybody within any employee of a planning and zoning department. And they also provided for this exception for attorneys. One additional point with regard to the training, at least one, so it's a 4-hour requirement during your term, which is, I believe, every 3 years. And of the 4 hours, 1 hour has to be on affordable housing and fair housing policies. So if you'd like, Chairman Wells or Steve or Brian, if you, Tammy, whomever, in the future, if you want, we could probably do a 1 hour training session just on that topic area of affordable housing and fair housing policy, so that our folks on the ZBA and Planning and Zoning Commission could get that requirement satisfied. If you'd like us to do that, we're more than happy to do so at some point in the future. The next section in the, and by the way, we purposely didn't give everybody the outlines, days in advance. We kind of wanted to go through this as we're presenting it. But the materials are available to you obviously for your future reference. Land use regulation, obviously that the city is a creature of the state, and so the city of Norwalk derives its powers for zoning by the Connecticut general statutes. There are some other communities in Connecticut that derive their powers for zoning from a special act of the legislature, and those are referred to as special act communities. Norwalk really is not. Some of those other places that are special act communities is like Greenwich, and I think to some extent New Haven. But for Norwalk, any powers that you have to regulate zoning there has to be an underlying provision within the Connecticut general statutes that would allow you to create a certain regulation. And so you again derive your powers from the general statutes. This section in the outline makes reference to materials, reference materials for you. Probably the best one is there's a Connecticut practice series, which a lot of lawyers rely upon. For many years, it was authored by former Judge Robert Fuller, probably for 30 plus years. He has retired, and a prominent land use practitioner, writer, author, Dwight Merriam, has picked up that mantle in recent years, and he now is the author of that Connecticut practice series, probably the best reference book for Connecticut zoning law. There's a few others out there. like Mike Ziska's What's Legally Required, but I think the kind of the Bible for as far as a treatise for Connecticut land use law is the Connecticut Practice Book series, known as also Fuller. And I would just always caution folks, Chat GPT and these things you could do online are great, but quite often they're not accurate. And particularly when it comes to local law, and particularly Connecticut zoning law, I've done some searches over the years with Chat GPT, and most recently in the last few months, and sometimes those results are not accurate. So with very local law, be careful of using resources like that. Lastly, for me is Section 824 of the general statutes. As you know, for certain applications, they have to come to the planning commission, and now that we've combined our planning commission and with our zoning commission to your commission for an advisory meeting, and you're aware of those applications, such as when the city is going to acquire or sell or lease land. And now I think we're going to move on to, is it Matt or Nick?
I'll take it.
Well, just before Nick starts, just for one moment, just to give you a little bit more of an introduction for Nick. He works in our firm's municipal practice group, and Nick provides legal counsel to a number of municipalities throughout Connecticut, particularly in Fairfield County, the towns of Westport, Wilton, Weston, Easton, and New Canaan. He's also the named town attorney for Woodbridge. So, representing municipalities, particularly in the area of land use, is Nick's specialty, and we're fortunate to have him participate in this orientation session. Thank you, Nick.
Thank you, Mario, for that glowing introduction. All right, good evening again, everyone. We're just going to keep rolling here. Obviously, there's a lot of information that we're going to be throwing at you, so please keep in mind we're always a resource. Ask questions as you have them. Okay, so in terms of, and whoever's, I think it's Attorney Sapienza operating the share screen, I'm going to jump around a little bit, so his life may be a little bit challenging right now, but I'm going to start talking about some of the timing requirements that state law sets out for how this board and when this board has to act. So for site plan applications, and only where under our zoning regulations a site plan is the only requirement, that application has to be decided within 65 days of the commission's receipt. Receipt doesn't mean when they hand it to the P&Z staff desk. It means when you, as a commission, have received the application at your next regular meeting and deemed it to be complete. Okay? It is a more generous timeline for your other applications. For subdivision, special permit applications, first, the P&Z has to schedule a public hearing if it's required within 65 days. Public hearings have to be completed within 35 days. And then once a public hearing is completed and the record is closed, the commission must decide within 65 days. Now, throughout that timeline, the law also allows an additional 65 days to extend that timeline with the consent of the applicant. And oftentimes, we see that for purposes of working with both the commission schedule. I'll just leave it at that. Applicants are normally generous to give more time where we need it to render a decision and fully appreciate whatever's come in the record. I'm going to move on from the timing requirements to legal notice. So along with these timing requirements, I mentioned public hearing. You all are obviously familiar with public hearings. the law requires that where there is a public hearing going to occur before this commission, we have to properly notice it. So what does that mean? Despite years worth, and it's ongoing, of effort up in Hartford at the legislature, legal notice must still be published in a local newspaper that has, quote, general circulation in the city, whatever that means these days. Nonetheless, your staff, P&Z staff, knows which publications are legally acceptable, and they know the required timeframes here. So trust your staff. But again, we're here for questions. And by the way, public hearings are noticed twice before the public hearing. One 10 to 15 days prior, and then the second at least 2 days prior to the hearing. In addition, your regulations also in many applications require that notice of a formal public hearing be mailed directly to abutting property owners. I'm going to move into participation and attendance. This is not anything new. You all know that you have been you have stepped into this role on behalf of your city and as a public servant. So it's important that you show up. Obviously, if circumstances arise that you can't, you should make contact with your chairman, chairwoman, and staff so that arrangements can be made to seat an alternate. That's what we have alternates for. And then if a member does miss and has been involved in an ongoing application but misses one, but still wants to be part of that discussion and ultimately part of that vote, then that member still does have the option, but they must review any recording. I mean, we have to record the public hearing, so you would have to review a recording of the meeting, review anything that comes in the record during that time frame, and then at the next meeting, enunciate that on the record that, yes, I wasn't here at the last meeting, but I have reviewed everything, and I'm fully up to speed and capable of rendering a decision in this matter. That's it on participation and attendance. Attorney Sapienza, you don't got to jump to the end of the outline here, but this is something that falls later that I thought might fit in here on voting. So in order to vote, or technically even to open up a meeting, a quorum must be present. That word quorum will come up again when I touch on, I promise briefly, a couple FOI elements. But really what it generally means is a majority of your members. For zoning commissions, the law gets a little bit more specific though. So in order to, that obligation becomes a little bit more strict where there's an application to either change a provision of your zoning regulations or to change a zoning boundary on the actual zoning map. For those and those applications only, the law says there must be a majority vote. In order to approve that sort of a change, there must be a majority vote of the total membership of the commission. So what that means is there are 9 total positions in this commission. So even if there's a vacancy, which I understand there's maybe 1 right now, even if there is a vacancy, so even if there's only 8 acting members right now, in order to change a boundary or to change a regulation, you need a majority vote of 5 in order to approve. That number really doesn't change for your purposes for other applications, but in those situations, it really just is a majority of the acting members. So if I understand correctly that there is currently 1 vacancy, if all 8 members, current members, are present at a meeting, again, a majority to take action on other applications, like a special permit, subdivision, a majority is still 5. The only reason I point that out, not to confuse everyone, just that, and sometimes this happens, let's say there is, I hope this isn't the case, but let's say someone has to resign. That would create another vacancy, which means the total membership of the commission could be 7. In that case, a majority vote to take action could be 4. So this can change, but I think the bottom line for the takeaway for this commission is you need 5 members to really take action on most, if not all, applications that are going to come in front of you. Okay, I'm going to move in to a few elements that fall under the umbrella of the Freedom of Information Act. Now, Freedom of Information Act really does 2 things. It requires that we hold and properly notice public meetings, and then 2, it requires that we make records available to the public. So under the eyes of the FOI law, which is a state statute, this commission is a public agency, which means you're subject to this law, this FOI law. There's certain obligations under FOIA for when you need to notice a meeting. But really what I want to talk about is what constitutes a meeting. Obviously, if so not obviously, I'll step back for a minute. The way the FOI Act defines a meeting is if there is, here's the word again, a quorum of members not only present together, but communicating amongst themselves. So while your normal meetings for commission business are obviously public meetings subject to FOIA, also if commission members are emailing each other outside of a public meeting, those communications, that conversation in and of itself, technically is a meeting under the FOI law. And those email communications, hypothetically, would not have been properly noticed to the public. The public would not have been able to attend that meeting, even though it's emails bouncing back and forth. It's just how the law works here in Connecticut. So I say all that to caution you all. Email is obviously a mainstream communication tool. None of us can live without it. Just be very careful about emailing amongst your fellow commission members. If you receive an email from staff relating to the scheduling of a meeting, or here's the agenda, here's the materials, those sorts of correspondence is okay. Anything even remotely resembling some sort of discussion about the substance of an application, stay far away from that. Site visits are also meetings. I understand this commission may have some questions about site visits or may be contemplating one. Again, if there's a majority, if there's a quorum of the members, here that's 5, attending a site visit together, that is a meeting under FOI. So what does that mean? It means we can certainly do it, but it just adds a few extra steps for staff to make sure that we do put an agenda out. Even though it's going to be a one-liner, it's going to say where it's to be held, at what time, so that if any members of the public want to attend that site visit, technically they can, because it's a public meeting of this commission. During that site visit, evidence from your observations can certainly be considered as part of your deliberations, part of your discussions on an application, but be careful. During the site visits, we strongly suggest try hard. It is hard, but try to avoid discussion when you're there with your fellow members, with anyone, really, and save that discussion for the public hearing. There's several reasons, but it's just difficult to track multiple communications. And another requirement under FOIA, as you know, you have to issue minutes after a meeting. So you will have to issue brief, but still issue minutes after a site visit. So bottom line, again, a site visit is a public meeting under FOIA, still has the same noticing requirements. Try to keep conversations to a minimum.
A question for you on that piece with the site visit.
Sure.
Is it appropriate to ask questions? I understand not having a discussion maybe as it relates to deliberations or otherwise, but is it appropriate to ask questions? Maybe what type of questions would be appropriate if so?
So ask questions to the property owner or the applicant's representative or whoever's going to be there?
Sure, or if it's like arranged by staff, you know, the staff person that's there, because I see in here that it's discouraged for the applicant to attend. So, you know, should questions be directed at staff? Yeah.
I think they I see Steve wants to jump in too. So whenever you want, Steve.
Yeah, we were actually just talking about that today.
Yeah,
and
right.
we were thinking, and this has to do particularly to your potential or the planned site visit next Wednesday night. And we would ask you only to ask questions related to what am I looking at? Where's the property in question? Where is this going to be? Not any substantive issues related to process or methodology or things along those lines. That would be something we would just prefer not happen.
Well, Steve, to that site visit that's currently planned for next week, it was my understanding, perhaps I'm wrong, that it is the property owner who wants to show us his facility. Clearly, he wishes to make a presentation.
No,
Is
they
it
won't
appropriate?
be. Yeah, they'll be. I have talked to his attorney about that, and I'm going to have another conversation before the meeting. But they will be there listening and observing, but not communicating or addressing the commission at all.
Thank you.
And we can always answer specific questions about, you know, through the normal channels. If you have legal opinions that you want, feel free to reach out to the law department about specific instances. But generally, yes, the best practice, I think, is not to discuss it, just in talking about site visits in general. Don't have discussions there. If the applicant has a presentation or something, that the appropriate time to make that is at a public meeting, which is a public hearing too. And I think that actually segues into, if Nick's done, I have the next session about public meeting.
I just had one
Sure.
additional comment on the site visit. So, as you know, it's a publicly noticed meeting, so I guess an interested member of the public could show up as well. And the rule that would apply to the property owner would be the same for anyone else, that you shouldn't engage in any discussions with anyone else, whether it be an interested neighbor or the property owner, or amongst yourselves as commissioners to chat amongst yourselves. And what I suggested to Steve is that at the beginning of the site visit, it's probably best when it starts for him to reiterate that rule to everybody, you know, and I think for him to kind of, as agent of the commission, take control of the site visit. And to the extent that to the extent the owner wants to have you look at certain things, he should make that request to Steve, and then Steve could direct the commission accordingly. And just as a practice tip, as you're going through the site visit, if there's something you want to write down, jot down for yourself, you could then bring it up when you have a meeting, and you know, and bring up something that you thought of during the site visit. You may want to, you know, jot it down, and then have it for your reference later on when you have when you have the public meeting, and then you could make a comment and others could respond to your comment.
And I think that
Matt, you can carry it away in 1 second. I just got to say this one more thing. As you folks might be able to tell, I've done a lot of work in FOI, so I will say one last time. I started the discussion saying FOIA requires public meetings and that we disclose public records. Those email communications I mentioned before, any email communications relating to your town business, any text messages, any voicemails. That includes if it's on your personal cell phone, your personal email accounts. If it's related to town business, it's discoverable, which means if a member of the public makes a request for records related to XYZ, those types of communications will be subject to disclosure. So be careful what you put in emails is the flag I will continue to wave. All right,
Hey,
whoever's next.
Just one more thing on that, because I think it's so critical. I mean, just to give you a little story to further illustrate the point. I don't know how many, I don't think any of you were on the commission now or on the commission when we had the Moss case many years ago. I don't think anybody was around, right? It was actually the application of denial was right before I came on, so it was about a little bit over 12 years ago now. But I dealt with the appeal. And I don't know how many are even familiar with this, the pretty well-known case we had, the Al Madani Moss case. And there's a lot of press on it as well. And it was a pretty significant federal court litigation. And at some point, there was a requirement that we do a search of any emails that a commissioner used for city business. And we did certain search words like mosque, Muslim, whatever, and there's a bunch of these words that we had to do searches on. And there were some emails that some commissioners had that I never wanted to see the light of day. Certainly I didn't want a jury to see it. And so if there's a commission that would ever end up in a situation where you'd have search terms run on the emails you use for city business, I hope you guys feel special, because it's probably you. You are the commission of any of them that would be the number one prime target for somebody caring enough in litigation to fight, to get supplemental discovery requests or to have a federal court action regarding a land use decision. More than likely, you'd be a commission that would be that could be subject to it. So whatever email address, whatever email account you use for the commission's business, whether it's personal or the city's, assume that email at some point in time, and it's unlikely, but could be this we could be required to do a search on it. Nick?
This is, I think, more for Steve, but are we still looking to get city email addresses for this? I know this is an idea possibly to get city email addresses so we can just channel all business appropriately.
Yeah, as soon as Mario mentioned that, I thought about that. Mario and I had talked about that, and then it kind of got put on hold for a little bit. But yeah, I think that's something we should talk about.
I'll just tell you, I recommended it. I said we don't need it for people volunteers on every single one of the commissions. And by the way, the issue is there is a cost issue, because for every single account we have, separate city account, there's a cost. And I said for certain commissions that would most likely be the subject of this type of a search. And I think I said, common council members should have a city issued email address. And there was like one or two other commissions, and it was in your commission was one of them. So I did suggest it, I think, within the last year or so. I know folks were looking into it. I didn't follow up. So this is probably thank you, Nick, for reminding us. This is a really good reminder.
Yeah, no, I appreciate it.
I think ideally for the Planning and Zoning Commission, maybe the ZBA as well, but maybe conservation and the wetlands, but definitely for planning and zoning.
And also what they should be able to do is the IT department should be able to make it such that we can only get emails from other norwalk@norwalk.gov email addresses, so we don't have to worry about people sending us emails randomly, because that's the one thing I would be worried about, is somehow one of our emails get out and then the public starts emailing individual commissioners separately. So I'm hoping our IT department can do that. That should be a pretty straightforward thing. I leave that to you,
I
Steve.
think about that. But yeah, possibly they could we could have that done as well. But yes, if you do get city issued email addresses, we'd request that you use them. But if you're using your personal as well, if you're using your personal at the same time you're using a city issued email address, and we ever end up in litigation where there's a requirement that we search the account you use. Even if, you know, you say, well, I use both, then both accounts will get searched. You're not going to just limit it to the city one. So the only way you're going to limit it to the city one is if you limit all your business to the city account.
Great.
So moving on.
All right, so I'll start talking about the public hearing and some other general concerns about the application as well. And Mario, I think we'll go back. I know we bounced around the outline a little bit. We'll go back to the conflict and bias provisions.
Sure, whenever you're ready.
Okay, so I'll open the door here. Talking about the public hearing and the record. So again, as Nick pointed out, you are a public agency. The real fundamental rule for all of your application processes is the rule of fundamental fairness. And so as part of that rule, the opposing counsel as well as the community is entitled to essentially know everything that you're basing your decision on, especially when we're talking about something with a public hearing, and they should have an opportunity to address that. So there's various forms of ways you can have information. Obviously, the information presented by the applicant, the information presented by any objectors or public comments. It could also be information such as a site visit. So again, you know, as we not to go back to the site visits, but our recommendation is not to discuss the site visit or talk really at all while you're at the site visit, other than maybe pleasantries. But the reason for that is when you get back onto the record, if you have anything about the site visit that is important to share for purpose of public hearing, that's the appropriate time to talk about it, because that way members of the public and opposition and the applicant have an opportunity to address it. So the record is very inclusive. And as Nick pointed out, all of your communications and comments. And so, but you should always keep in mind that the goal of this is fundamental fairness. And the biggest kind of legal issue that comes up with that is someone wasn't aware of information that you relied on in coming to your decision, and they didn't have an opportunity to address it at the public hearing that they felt they should have. And that's going to be a strong ground to overturn many decisions. So the important thing to do is if you have information, present it to the public. And this goes for, that's one reason why ex parte communications are banned. So again, if includes communications between yourselves off the record, as well as communications from members of the public. Sometimes you might be out socially, or as Nick pointed out, if you were to ever get city email addresses and someone emailed them, anything that if you see someone out in public, you should, politely kind of shut down the conversation. Thank you for reaching out to me. Please come to our duly noticed public hearing and present your arguments there, so everyone can all the other board members can fairly hear it, and members of the public as well. And same thing if that ever happened where you did get a stray email, the correct cure as best you could would be to forward that to the entire board so that everyone can review it and it's part of the record. And so when we get appeals, when we're, one of our tasks from the law department and with help from zoning staff is to compile the return of record. And again, the record is all documents that really have reached any of you on which you could have relied for your decision. So the record is very comprehensive. There's also questions about kind of for public hearings, the procedural structure of how a public hearing. Usually the applicant presents, and then the public or any objectors, raise their testimony at the public hearing. At the close of the public hearing, usually the applicant, once the public hearing is closed, the applicant usually gets a small rebuttal opportunity. Again, and this comes up, the applicant should not be presenting new information during their rebuttal. It should only be generally addressing some of the comments that were raised by the public comment. But you shouldn't take new information from the applicant, and you shouldn't expect to receive new information at the close of the public hearing. So kind of tentative, we've seen situations where boards have tentatively closed the public hearing. Don't tentatively close it. Pending, maybe receipt of information from other sources. Again, get as much information, all of it, in for the public hearing. There are some narrow exceptions for technical information and that's usually experts retained by the agency. Sometimes that information and same with legal opinions can come in once the public hearing is closed, but everything else, make sure everyone's got their chance to talk at the public hearing and address any issues that they can to the best that you're able to facilitate that. Someone were to, during the applicant's rebuttal, they were to raise new information, or if an objector raises new information, you can give the applicant an opportunity to address that new information, then offer a rebuttal, in objection to that as well, just to make sure everyone gets a chance to address new information. The goal is fundamental fairness. And again, if specific issues come up, you can always feel free to reach out to the law department for a specific opinion on a specific issue.
Can I ask a quick question on that?
Sure.
I just wondered in keeping with the fundamental fairness. I've been at a couple of meetings where at the end, when we were talking before we were going to vote, there was disagreement between the commissioners as to what was factually presented. And I've been at meetings sometimes where the applicant would answer the question, and at other meetings when the applicant was unable to answer the question because the meeting was closed. What is the story on that? I'm not talking about, an objection or something. I'm talking about, I wish I could remember what it was. It seems to me, I thought it was something like the location of a buoy or something. But it was just a factual question.
Sure. Once the public hearing is closed, it's very difficult to obtain any more insight on that question. So the best answer is try to get all your questions in while the applicant has an opportunity to respond. Some of that, hopefully the applicant presented their case well. And then otherwise, if there is a factual question, I guess that affects the applicant's credibility. If you thought that was kind of an intentional
Well,
mislead.
no, I think it was more an issue of a lot of times when there's 9 people listening to something, there's 4 different ways it's remembered. And I just think it was a question of I remembered it one way, let's say, and somebody else remembered it another way, but it was not a legal or judgment thing. It was where is something or what was something.
I could jump in.
I think the best
that's where
thing
your
would be
staff
for you.
could come in. I think your staff could come into play as well.
I'm
Yes,
sorry, I didn't
you
hear
can
you.
talk.
Your staff could, when that happens, I think that even if the public, Matt gave this important distinction when the hearing is closed, you're not supposed to hear any further from the applicant. But I think you could go to staff in a deliberation session and say, Steve, Brian, I think we're a little confused as to where the buoy was here. Can you please verify that for us? And I think you've got good experienced staff. They know how to handle themselves. So they will get you, I think generally they'll get you the answer. And if it means that somehow, however they get it, I think they'll get you the answer. And I think if you work through your staff, you do in a deliberation session within certain limitations, have the ability to work with your staff to ask questions, like questions of clarification. But
Okay.
obviously, your staff can't go too far either in the deliberation session, but I think they know how to walk that line. Matt, were you going to say anything further? I could see Nick wants to say something too, but Matt, I didn't mean to jump in on you.
No, I think I was just going to say you could obviously you're going to hash it out with each other as well. So I mean, if there, you said there might be 4 different ways to hear it. So obviously, you will all, the board members themselves will be able to discuss with each other, and perhaps hopefully you can one of you can convince the others about. But if it's really just a factual issue, again, that's probably somewhere in the record. So even if you take a break, staff can help search the record and point you to that reference. And that way, it's not new information. It's just maybe something that's in a filing. If it's more than that, again, it could be a case by case basis of whether it kind of constitutes new evidence or not. But Nick, did you have something too?
Just that, if there's time still to render a decision, and that sort of a question, Rich, comes up during, the discussions amongst the commission that, oh, well, I thought they said this and I thought they said this. Meanwhile, the public hearing's closed. You can't get clarification from the applicant. And you could ask staff for clarification based on the record, and whether that's going to be, really clarify things or not is sort of up in the air. So what do you do? Well, I mentioned those timeframes earlier, the 65 days, 35 days, 65 days. If you're not up on a time crunch, there's nothing that says you need to make a decision then and there. I mean, if you have time, kick it over to the next meeting, and in between, ask staff to try to shore up whatever they can to answer that question. That would be my suggestion.
Can I
Very
ask
good.
a slightly related question related to, I guess, ex parte communication and bringing information into the hearing? I know you talked about if somebody had sort of emailed us, we could forward it to the whole commission or forward it to staff to make sure that gets included in the record. If, let's say you're outside and there's an open application and a neighbor walks past and said, I want to make sure you know that 12 Morton Street is protected by a historical whatever, and what's happening isn't allowed to happen. And you say, sorry, I can't talk about it. If you have thoughts, come to the hearing on Tuesday or whatever. Can you also, whether or not the person comes to the hearing to share the information the appropriate way, sort of address the ex parte concern by raising that yourself and saying, like, I heard from somebody, or I wanted to ask the question, is there any sort of historical blah, blah, blah related to this property? So that you're getting it out in the open, everybody knows what might be on your mind, the applicant can respond, whatever.
That's a great idea, and that's probably actually not can you, but that's what you should do.
you?
Yeah,
Yeah.
that is the recommended thing, is that if there's, again, the potential worry is that if you make your decision, someone else can appeal that finds out that this neighbor said something to you, and then that could be the basis of the appeal, is that you receive this information. Again, it's not always going to win every time, and it's got a materially impact the decision, but it opens the door to an issue. So the best way to cure that is, once you tell the neighbor, politely, thank you, but please go to the hearing. If they did give you kind of a substantive piece of information, present that at the next meeting and say, I was approached by neighbor XYZ, and this is what they said to me. And that way, if there is a public hearing coming up, that everyone knows about it, and whether other members of the public or the applicant or opposition can address that comment. That's the biggest thing, the fundamental fairness, that everyone gets a piece or an opportunity to address the specific piece of information you rely on. But that's a great cure. That's yep. Mario, your hands up.
I just had one thing though. If somebody makes contact with you, sends you something after the hearing is closed, do not put that into the record necessarily. I think, that's where come talk to the law department and let's discuss it. But generally, one concern I would have is if the hearing is closed and somebody, sends you something, and now you're saying, well, do I have to now disclose this to the commission? Essentially, you're allowing somebody to have the opportunity to put something into the record after the hearing has been closed, and that would be improper. So
Right.
If you end up in a situation where somebody sends you an email after the hearing is closed, but before you've deliberated, and you feel compelled to bring it up to the commission, come talk to us first, because it may not be appropriate because it was provided after the hearing was closed.
Yeah, I think in most cases, we're just going to tell you, I'm sorry, that's not part of your considerations for this application.
And there,
I was thinking more before the hearing was closed, but that's helpful to know.
Yeah.
But the best thing to do is to tell folks you can't talk about an application, but on the record, and to try to avoid the ex parte conversations, to try to limit them to the point where you don't feel compelled to bring anything up to the commission, and and to have it all on the record.
Okay, so I think we've covered that, Mario. I think we'll go back up to conflicts and bias if we want.
Sure. So sort of a fun area, for as fun as you could be, as this type of stuff could be, right? So conflict of interest. Again, I mean, you're an important, you are really an important board and commission, because, I think where you do have conflict issues raised, it's most often in the context of a planning and zoning commission. And so, each member, has to determine whether he or she has a conflict of interest, which might disqualify them from participating in the consideration of the application. I can't make that decision for you. Steve, Brian cannot make that decision for you. Certainly, Steve or Brian or your chairman could say to one of you, hey, you know, you may have a conflict here. I don't know if you want to consider recusing yourself, or you may want to speak to the town, to someone in the law department. But ultimately the decision is yours. I do encourage any of you that are trying to figure out whether you have a conflict or an appearance of conflict, which is more often the case, that you reach out to either Matt or myself, and we're more than happy to provide you with confidential counsel to help you figure it out. And you know, conflicts exist whenever, for whatever reason, you, the member, are compelled to consider the application differently than you would for a different application. And that's why the determination as to whether you have a conflict should really be up to you, because only you know whether you're going to be compelled to consider something differently based on some reason or some relationship that you have. Having said that, you shouldn't just recuse yourself for a conflict. You should also recuse yourself for an appearance of conflict, where maybe you don't have an actual conflict, but somebody looking at the situation would say, I think, you know, Commissioner Bamonte here may have a conflict. If the relationship you have with an applicant or somebody involved in an application, even somebody opposed to it, would make a reasonable person question whether you have a conflict, that in and of itself is an appearance of conflict. And why is it important to recuse yourself because of an appearance of conflict? Because you are serving the public trust. There's already enough questions that people have about the integrity of public officials. And so it's incredibly important that the public has trust in our public institutions, including your commission, which is an incredibly important commission, because you know, you're as you know, you're making the rules, and you're approving, making the rules for what could be developed in the city, and you're judging applications as to whether or not they could certain projects could be developed in the city. It's an incredibly important commission. It's important that the public has trust in the work that you're doing, and particularly that you're doing it in a way that's fair for everybody involved, the applicants and anyone who may be interested in the application or opposed to it. What are reasons for a conflict or appearance of conflict? Usually they're personal and financial. Clear conflicts are family. You know, if you have a family member that's involved with the application, whether your family member happens to be a lawyer representing someone, or is a other professional involved in the application, or your family member is the applicant, or if your family member is interested in the application because it's, you know, next to their property. And by the way, this also applies to in-laws. Even if you don't like them, they still qualify as family. I've had the question before, how far does that extend? What if it's a third cousin? I mean, anybody who's a family member, you probably should recuse yourself, even if not just because you have a conflict, because maybe you don't have a close relationship with them, but it's at least an appearance. Because if it comes out that your second cousin had an application, even if you don't have a close relationship with the person, if that comes out, it's going to at least be the appearance of conflict, especially if you have the same last name. Anybody you have a business relationship with, and so that would be somebody that, you know, if you work at a company, is that your company or has a business relationship with your company? Personal relationships, I think, are the more difficult ones, because all of you know people in the community. Many of you are probably outgoing and know a lot of folks, and it's fine to know people who come before your commission. You don't have to recuse yourself just because you know somebody. At what point does your relationship rise to the level of a conflict or an appearance of conflict? And I think the answer is twofold. One, with regard to conflict, is a relationship one to the point where I'd feel bad turning them down more than I would someone else. And the second is, you know, where is it that at what point that is there an appearance that based on our relationship, even if I wouldn't treat them any differently, where would somebody look at the situation and say, wow, you know, their kids are best friends, and you know, and you approve the family's application for something. Does it not look right? And those are the tougher calls. You know, in the past, my partner Ira used to talk about like the wedding test, the birthday test. You know, if you were close enough with somebody that if you had a birthday party, you'd invite them, or a wedding for one of your kids, you probably have a conflict. You know, I think I'm at this point where we're going to a lot of sporting events for my kids. So, you know, just because if I was on a commission, just because I recognize the applicant because maybe I coached their kid in youth sports, or their kid was on the same team as mine for one season, that in and of itself probably wouldn't be a conflict for me. But if it was somebody who plays on a team with us where we're traveling all the time and I see them almost every weekend and we've had dinners together because we've been out of state at tournaments together, there's probably enough of a relationship there where I've got a conflict. Any questions on conflict before I move on? All right, so next is bias and predetermination. With regard to bias, it's what it sounds like. That the commissioner has a prejudice to a certain application that would improperly influence his or her decision. And if the court finds that the commissioner was biased in considering the application, decision could be overturned on grounds that the application was not processed in a fair, equitable way. Predetermination is not based on the statute itself, but a finding that the commission member has made up his or her mind as to the application. And so, with regard to bias, generally, it's hard to prove unless you've said something on the record that would lead somebody to make that claim against you. And the same thing with predetermination. Generally, it's something that you've said about a project on the record somewhere. A lot of times in this day and age, it's via social media. That would lead somebody to the conclusion that you predetermined the application. So our advice is, you know, you're in a public position, and with that there's some limitations on what you could do. So if there's, you know, I think any of you who are on the Planning and Zoning Commission, my advice to you is that you should not comment while you're on the commission publicly about any potential development project that could come to you in the future. Now, I know this was a little bit, maybe more of a difficult issue sometimes to grapple with, but I think to a certain extent, depending on what comments your partner or spouse would have, that could impact you as well. And my wife doesn't always listen to me. She almost never does. Certainly she has a mind of her own. But, you know, if my wife was outwardly had comments one way or another about a project, I would feel compelled to recuse myself, because somebody can make the claim that, you know, Mario has a predetermination or a bias about this project, not because he ever made any statements on the record, but his wife did. So certainly, you know, just be cognizant of not only what you say, but what your partner or spouse says could lead somebody to making that claim of bias or predetermination against you. Sometimes what happens is an applicant or someone who's opposed to an application would put right on the record, Commissioner so-and-so, I believe, is predetermined this application. And here's a copy of a comment that he made on Nancy on Norwalk a year ago about this potential project, or that is his or her spouse made. But sometimes what happens is after a decision is made, a plaintiff files a motion with the court to supplement the record and tries to take a deposition to establish that a commissioner was biased or predetermined. Doesn't happen often, but it has happened in the past. We had a case in Westport many years ago where there was lots of depositions taken, and ultimately there were no determinations of the court that anybody was predetermined or biased, but it was a big application, and we ended up having a lot of those depositions. Excuse me, Tammy?
Yes, thank you. You don't mean that if we're in a public forum in our meeting that we can't say how we feel about an application, though?
When you say public forum,
right?
You
if
mean
we're opining, we have the application, the process has gone through, and frequently some of us say, well, we like this application because X, Y, Z.
Well, you certainly should. I mean, you should be stating your reasons why you're in favor or opposed to an application, and we encourage that for you to do that during the hearing process and more importantly during the deliberation process.
Okay.
But what I'm talking about is when when folks are providing comment regarding an application or even a project that hasn't even been approved, or they haven't even applied yet to the commission, that's where it could lead to comments of bias or claims of bias or predetermination. I'll give it a good example. The mall project we had years ago. They went through almost like a charrette process where they tried to engage the community for a long time before they actually applied. If you were commissioner at that time and you commented about the project on social media, you're putting yourself in a bad position because ultimately at some point they're going to come forward to your commission. Another example is the Manresa Island project. I mean, there's been a lot of media coverage about the acquisition, and there's been already public meetings about what potentially could go there. For any of you on the commission, I would encourage you not to make comments publicly about that project because ultimately they're going to come to the Planning and Zoning Commission at some point in time, and then you would have to adjudicate their application after having made some comment about the property or a potential project, and that would be a problem.
I think during your actual application deliberation, I think you could speak, and I don't know if that's what you were asking or not. I think, Tammy, but you could speak pretty freely during the actual application review. I think the biggest time bias and predetermination come out are outside of your formal application review, whether that's social media or even during an application review of as Mario suggested with other applications, talking about some kind of theoretical or other application that you expect to come up in the future. Again, now, especially with social media and recording of meetings, that stuff's happening a little more frequently in the legal sense than it used to. But while you're in the middle of the actual application deliberation portion, you can speak, it's relatively freely, and it's difficult you'd have to be pretty extreme to get a bias or predetermination adverse decision based on what you're saying during an actual deliberation portion about the application in front of you.
One thing though I do want to make you all aware of is and one time during deliberation session when you do have to be careful about saying anything is if you're an alternate member and you're not actually voting on the application. So and different commissions handle this differently. My suggestion is if you're an alternate member and you sat on the application during the hearing process, maybe you ask questions then, but when it comes to deliberations, if you're an alternate member and you are not voting on the application, you should not make any comment whatsoever during the deliberation session. And quite frankly, I don't think you should even be on the screen if you're an alternate member and you're not voting, because the case law is pretty clear. If you're not a voting member, then you have as much of a right to speak during a deliberation session as any other member of the public, which is none. So, Steve, how do what do we do with alternates not voting on applications?
We haven't asked anybody to turn their screen off, but we, typically no one, unless they're seated, is speaking.
Yeah, I mean, I think best, you could leave it on, I guess, but I would be really careful. I mean, don't make any facial expressions, et cetera, if you're not voting. I've never taken the position that, like, if back in the day when we had everything was live, that you had to leave the table if you were an alternate and you weren't voting. But just be really careful if you're an alternate and you're not voting, to not say anything in the deliberation session. Sometimes, you don't think about it and you say something, maybe even just trying to be helpful to folks, and that could be a real problem. So be careful in that regard. Does anybody have any questions about conflicts or bias or predetermination? Okay, great. And as I think Matt said, if you ever have a question about something, feel free to reach out to us. More than happy to provide you consult on a one-on-one basis for any issues that come up in any of these areas, particularly conflict or
I'm sorry,
bias
one
determination.
quick question about the predetermination. Let's say like you're given the story of the mall or Manresa, right, is a big topic right now.
Mhm.
If somebody who's, say, not a commissioner at this time, or maybe even is a commissioner, makes a comment or has strong opinions and feelings about, let's say, Manresa or something else, and then 5 years from now, it comes to the committee and maybe this person who wasn't a commissioner then is now a commissioner, or they were a commissioner but weren't anticipating 5 years down the road. Can they address it by recusing themselves from that application? Say,
Sure,
you know what, I screwed up 5 years ago. I had really strong feelings. I shared them. I think I can be objective, but just in case, I'm going to recuse myself.
Yeah, and I don't even know if you have to go to the extent of apologizing, just to say, I've made some comments about this application in the past, and about this project in the past, and just on the erring on, I don't think I have a conflict, but erring on the side of just I don't think I'm not biased. I haven't predetermined it, but just to make sure that there's no appearance of that, I'm going to recuse myself.
Okay.
And sometimes you don't really need to state the recusal on the record. You just say I recuse myself on this application. But I would always err on the side of, if you made a public comment, even when you were not a commissioner, and now you are, about a project, I would recuse myself. Because especially if it's a big project and there's people who are opposed to it, I wouldn't put it past anybody to run a search online to see if any commissioners made a comment or have any relationship to a project. If they find a comment you made, even when you weren't on the commission, that may be the best argument that they have to fight the case, to fight it. So don't put yourself in that position. Be careful. Anything else? Any other questions? All right. And by the way, Steve, I think the plan here was to try to do an hour and a half, so that we have an hour and a half of time for purposes of training, so that we have a record here that folks have done an hour and a half of training, but that you want to stop at the hour and a half mark because you had some other business that you were planning on doing at 7:30. Is that correct?
Yeah, and if you need a few more minutes, however, I think that would be fine.
We could go as long as you want, but I think you wanted us, the plan was for us to end at 7:30, not go all the way to 8 o'clock. Is that correct?
That would be ideal if we could, but
I think we're almost wrapped up with our.
Yeah, we're
with
here
the
to please. So whatever we'll do, we'll
questions, but
work
we're-
within the time constraint, not an issue. So moving on, who's next? Matt or Nick here?
I think that mostly wraps up the presentation. Unless, I think the executive session, we could touch on that again. That's part of the kind of FOIA discussions. Oh, and enforcement. That's actually a big one too. So I'll start with enforcement, or I'll do executive session first because it's tied into most of what we're talking about. So during the public hearing, obviously there's limited reasons why you can go in executive session. You should state beforehand which of the reason that you're going into executive session, what that reason is, and those reasons are statutory. I think there's about 5 of them. Before you do so, feel free to consult with staff or the law department. Will tell you most common one is probably settlement of litigation. For other departments, there could be other common reasons are employment related, which probably won't affect your commission much. The biggest one would be settlement of litigation. So you would then go into executive session. Only the board members are there, as well as council and staff as well. And then you're able to deliberate the matter during executive session. And then when you get when you're done deliberating, the vote, you leave executive session and then you vote on the record. So the public has a vote. And a relatively newer provision of executive session is that you're supposed to state your reasons for the decision on the record as well. There's not a lot of litigation on kind of what the depth of stating your reasons are, but that's something we're kind of monitoring case law on as it progresses. So then going to enforcement, there's 2 real enforcement mechanisms for a planning and zoning commission, or a zoning commission especially. One is the traditional way, which was really if someone violated a zoning law, there's a statute called numbered 812, and that allows the zoning enforcement officer to issue a cease and desist letter. And then within a certain amount of time thereafter, it could go to the Superior Court for enforcement, which so in practical terms, that meant a zoning enforcement officer issued a cease and desist letter. And then after a little bit of time, about 14 days, it would go to the law department and we would have to file a formal injunction with the court. Injunctions are pretty intense, time intensive processes. It's really bringing a full-fledged lawsuit. There are temporary injunctions that the court could issue, which are could maybe still usually take about at least maybe a month or 2. And that's if things are going well. And what a temporary injunction is essentially that the court is kind of ordering someone to stop doing an activity temporarily while the fuller fledged injunction is being litigated through the court. As I said, a full-fledged injunction is a normal civil lawsuit, which on average could take 1.5 years to almost 2 years, is kind of the average life of a case in Connecticut. There's discovery, both parties get an opportunity. There's a lot of due process issues that go in as there's formal rules of evidence. So sometimes temporary injunctions can be useful. Sometimes they're not as useful because, quite frankly, the zoning enforcement officer has already told this person to stop doing what they're doing. And now you're getting an order from a court, which is, much more convincing, but surprisingly, some people, there's a tendency when someone ignores one notice that they tend to ignore other notices as well. So there's another enforcement mechanism. Because of that kind of laborious process of bringing an injunction, a lot of municipalities were really backed up with their enforcement mechanism. So there's another general statute, 812A, which allows municipalities to kind of create this municipal citation hearing procedure. Norwalk, I think we were almost ahead of the game in creating ours, and it takes a little while for the municipality to kind of get that process running smoothly. It's almost similar to running an in-house court system, because you have a hearing officer that's independently appointed, and that hearing officer is a member of the public, usually an attorney, and they kind of have the rules of evidence and they make decisions according to statute. And I know Norwalk, that's the main way we enforce our mechanism, and the legislature allows municipalities to issue significant fines now. And this enforcement, this kind of citation hearing process has really increased in severity over the past decade. It started off like most things, providing some power, but in recent legislative actions have made the amount of the fines pretty severe. I mean, I think you could, in some cases, it's almost $1,000 a day for the violation. And then the liens can now almost be collected as tax liens. So they have a priority kind of collection process, and that's pretty recent. So it has been slow going at times, but it's really kind of becoming a powerful enforcement tool. And I think the city of Norwalk's citation hearing process is in running pretty well. I know they're public meetings, and they I think our enforcement rate, I don't know if there's stats, but I think there's a pretty impressive enforcement rate as compared to any enforcement arm of the city. So, I mean, if you were to look at police or health or building or any kind of department that has an enforcement arm in the city of Norwalk, and you were to kind of consider the amount of complaints that they get that end up being legitimate, because obviously some complaints there's no violation, but the amount of violations that are found in had those the percentage of those violations that get cured, what I've seen the zoning, sometimes it takes longer than people like, but it's pretty good, and it's a lot shorter than the injunction process of about 1.5 to 2 years. It's usually shorter than that. So
I would say, just to give some context, when I came to the city 12 years ago, there was no zoning enforcement ordinance. So there was no mechanism by which the zoning department could issue fines. The underlying ordinance that allowed the zoning department, the ZEO, to issue fines didn't exist. We also didn't have a blight enforcement ordinance over 12 years ago. And so both those ordinances were enacted you probably 10, 11 years ago, plus minus, and it's the amounts of fines and our ability to process fines both in blight and zoning has increased over the years in some regard because of the underlying legislation that amended the underlying statutes to allow for there to be a more a significant process for the fines. And so I think both the zoning department and the building department handling blight have done a great job over the years in increasing their enforcement processes. And it takes time, because the flip side of it is that property owners have due process rights, and we talked a lot about enforcement, but part of the biggest part of enforcement is working with folks and trying to get them to fix a situation. And I think where folks recognize, okay, didn't realize I had a mistake, or maybe I did, and now I'm going to fix it, and they work with staff. From what I've seen, and I've got, I think, the benefit of also working with other communities in Fairfield County. I think the Norwalk staff goes out of their way to help to work with people, to be reasonable, to give them an opportunity to remedy a violation. So it's never going to be perfect. For folks who live near a property that has a violation, they're not going to be happy with how quick the enforcement happens, no matter what we do. But I could tell you that the amount of enforcement that the city has done for zoning violations as well as for blight is substantially more than 10 years ago. So and I think you see the results around the city. There's certainly a lot less violations of the regulations than there was in the past. Steve,
How often do you guys watch these recordings of the hearings?
You mean of your meetings?
No, of the zoning violation hearings, the city attorneys, the people,
Depends how bored I am.
Sapienza. Yeah. They're
no,
2 times a month now. I'd encourage everybody to watch a full one currently.
Great.
Yeah, I mean,
sure. And we haven't had many appeals. I haven't had to in a legal sense, because I think we've only had one appeal. The hearing officer's decision could be appealed, and as far as I'm aware, there's only one appeal that ended up getting withdrawn to the Superior Court. Yeah, we'll I think questions here to there, but sure, yeah, keep an eye on them. We will keep an eye on them. But if there's questions in the meantime, feel free to reach out as well.
And by the way, just since Anna made reference to the hearing process, the way it works is we have a hearing officer that's assigned. There's a few different hearing officers that we use. They're volunteers, they don't get paid. I think all of our hearing officers are attorneys. We're fortunate to have enough attorneys in the community to generally get them to serve in this role. And generally, we've gotten folks who have some experience in land use that are handling the hearing processes for zoning citation matters. And it's a requirement of state statute that any violator has the ability to have a hearing and to be able to appeal any decision. And furthermore, that before we get a judgment, a lien against someone's property for a zoning citation, that it goes before the hearing officer and the hearing officer signs off on it. We need that sign off from the hearing officer and then to file a form with the court for us to get a judgment. And only when we get sign off from the hearing officer after a hearing process and a sign off from the court after filling out a certain form, where again, the violator has the ability to participate in the process. Only after then the court issues an order are we able to put a judgment, a lien on someone's property for a citation. So there's some safeguards in place to allow for violators to have an opportunity to work with us to appeal and to have, their due process rights in the process. Anyone else, any further questions on this? Or anything else that we covered? All right, well, if not, thank you very much for.
Mario, before
Yeah,
you,
sure.
if I may, it's not directly related to this presentation, but I know it's something that occasionally annoys most of us. And that is the length of time that people are permitted to speak. We have no restrictions on how long people can speak at our public hearings. Now, we try, if they get repetitive, to remind them that they are being repetitive and ask them to keep their comments as short as possible. But do we have any flexibility beyond that in terms of how long people can present or speaking? I'm not speaking now necessarily about the applicants. I'm typically speaking about people who are in opposition.
An excellent question, and I want Nick to provide his comment as well. Matt, feel free to chime in too. But what I would say, you can set rules limiting public comment to a certain period of time. Any rule you have should be must be applied uniformly to all members of the public who would speak about something, and obviously you're going to give an applicant more time. If you could avoid having a time restriction on public comment, I recommend that you try to do that. You could, for an application that's really significant, that you know there's going to be a lot of people who want to speak about it, set some sort of a time limit for a one-off type application. But I think you got to use your judgment there. And I know the council uses a 3-minute time for people to provide public comment. I've seen other commissions do anywhere from 3 to 5 minutes. I'd probably err on the side of 5. And,
we have people who present for half an hour.
Yeah, I could imagine. So
We have people who bring PowerPoints, and have long presentations.
Yeah, no, I get it. And you have a very important job. You certainly don't have an easy one. It's a tough job. You got to put a lot of time in. So I see Steve's hand up, and then maybe Nick could provide his comment as well.
Yeah, I remember being at a Connecticut bar seminar, not Connecticut bar, but Connecticut planners, where they had, not sure whose mic that is, but we were specifically told we cannot place time limits on the length of time someone's allowed to speak. That if what you could do was say, we're going to limit the initial round anybody is to like 3 minutes or 5 minutes, whatever the time is. And then anybody who wants to speak further after everybody's had a chance to speak can speak again. But we were told we're not allowed to legally cap the time.
By the way, I think that is the right advice, that it would be preliminary, you know, if you have an application where you know you have 50 members of you see there's 40, 50 people lining up to speak, that's the way you would do it. You would limit it for the initial comments, but then cycle through after, you know, at some point and say, if anybody really feels compelled to say something else and please don't repeat what you've already said, we'll give you an opportunity again. Nick?
Yeah, I mean, I don't have much else to add to what Mario and Steve said, except that you just got to do your best. You have a strong chairman, chairwoman who, you know, when they start repeating themselves, say, you know, excuse me, sir, you know, can we keep it relevant? You know, we've got other folks here. We have a whole, you know, hour to go. You use what you can to sort of move people along, but no, the bottom line is we as the attorneys can't say you can legally set a strict timeline and then hold everyone to it.
I think for fairness, I would prefer saying 5-minute cap first round, just to, I mean, there are some people who know that they speak for a long time and they intentionally try to go last so that they don't hold up other commenters. But we also have a lot of commenters who may not intend to go on for 10 minutes. But they do. And when there's 50 people waiting and 20 of them speak for 10 minutes, I don't think it's fair for everybody who showed up to speak, especially like in person. You can sort of see where you are on the list. When we're doing it virtually, people don't know when it's their turn to go. I don't know if that's something we can consider doing for some of the larger things.
Yeah.
I think on the larger ones, I mean, as I said in when I first provided comment was, I don't advise generally doing it. And I think you should avoid having time limitations. And I think, as Nick suggested, you know, the chair could hopefully move people along, which is, and give those reminders. There's a lot of other people who want to speak. Could you know, we could keep moving it along, et cetera. I've seen Lou over the years. I've seen him do that, I think, very effectively in some applications I've watched where he's had a lot of people speaking. I've seen him interject at the appropriate time, and that's not so easy to do. But I think he's done a really good job of it. So again, on a really big application, maybe you, as Steve suggested, do it in the first round, give a time limitation at that time. Galen, did you have a question or comment?
I was just going to say that, you know, if we limited it to 10 minutes, we'd be cutting some people short, you know, where they go way longer than 10 minutes and they get enraged if you say you're repeating yourself. I remember Lou reasonably saying, you know, really trying to limit somebody to trying to suggest that they'd already gone over the material, and she got really angry.
I think what happens too sometimes is some people aren't accustomed to speaking at any kind of meeting and they just don't know how to exit. They just kind of they get to the point where they stop making their point and they just keep talking when they've kind of completed the point, and they just kind of don't know how to exit. So that happens a lot too.
And you might be able to just point out the amount of time they've spoken. If you kind of do that uniformly, that might, without cutting them off, you might be able to kindly say, you know, you've been, just so you know, it's about 10 minutes or, and if you come do that uniformly without actually stopping them. Some people just, like you said, they don't realize how long they've been talking, and 10 minutes can go by quick when you're passionate about something.
It's not easy to be a good commissioner on a planning and zoning commission, and it's even harder to be a good chairman. So a good chairman will eloquently and delicately try to move along folks. And sometimes, no matter how gracious and somebody may be and trying to do that as a chairperson, you may get somebody who's rude in their response and gets disgruntled about it. And there's nothing you could do. I would still encourage you to try to do it. try to move folks along. And it's not it's not easy to do, but I would encourage you to do so where things are not moving along. It's a long meeting, and a lot of people want to speak on an application.
Thank you for your comment, sir. Thank you for your comment, ma'am.
Yeah.
Well, thank you all for your comments. And
Thank you. Is anything else?
That's our cue.
Don? All right, well, then that's our cue. Thank you very much. We're more than happy to do this again in the next year or two. And if there's ever another subject area you want us to provide training on, I'm more than happy to do that as well. So thank you very much for having us this evening.
Thank you. Thank you so much.
Good night.
Thank you.
Good luck,
Thanks,
everyone.
Thank you.
Appreciate it.
Thanks.
thank you.
Thank you.
We will adjourn here and go. How do we do this, Steve? We need to now open it to the public.
Yeah, so you're just going to move on to your next item on the agenda unless people needed to take a break, but I'll leave that up to you folks.
Does anybody want to take a few minutes for a break?
Everybody but Nick.
I have to go put somebody to bed. So if we're not going to take a break, please don't seat me on the first, whatever it is.
No actions.
We're actually voting on anything this evening.
Oh, we're not? Okay.
Presentations. Okay. Let's see. So is everybody on? Just us or the?
Yeah, it looks like we have both applicants on.
Okay, we have both applicants on. All right. Then why don't we just move on? Why don't we take a vote? Do you want to take a 5-minute break or do you want to go forward? Nick voted. Does anybody else have an opinion on this? You want to take a 5-minute break? Raise your hand. Okay, it's a minority, so I guess we'll go forward. The first matter come before us is the 2025-15 R/SP Norwalk Center LLC and the Auto Collective, 10 Norden Place. It's District 3, Block 17, Lot 40. They are asking for a zoning regulation text amendment to amend Article 4 and Article 9 to create a car club use within the SD-LI zone district and special permit application for an A+ minus 137,000 square foot car club within an existing building. All right, who is here for the applicant?
I am, Madam Chairman.
Wonderful, thank you.
Thank you, Madam Chairwoman. For the record, my name is Liz Succi. I'm a partner at Carmody, Torrance, Sandeck, and Hennessy. Good evening, everyone. I represent the owner of the property, Norwalk Center LLC, which is an applicant along with the Auto Collective. Proposal before you is to use 137,000 square feet in the northeast corner of the existing Norden building and create a car club in that space. That would be where private vehicle owners would bring their vehicle and store them there for small periods of time or long periods of time. Luxury cars, classic cars, or just vehicles that they want to store indoors and don't have the ability to do so on their own property. The vehicles would be brought to the site by the owners, not by some sort of large carrier transport, and they would be stored indoors, no outdoor storage, no outdoor work. There would be no auto repair or that type of work conducted on the inside. But just by way of background, as you all are very aware, 10 Norden Place was the former, half of the site with former Northrop Grumman national defense contractor up until the, I guess, mid-early 1980s. The parcel was about 80 acres in size. It was subdivided in the late 80s, early 90s. And the remaining portion in the front, which is the western portion of the site, it's about 33 acres. The building that is there today is 600,000 square feet plus. A 3-acre parcel was divided off about a year ago, and that is where Corville Nurseries currently operates its business. And there is a piece of land that the State Department of Transportation is using in connection with the walk bridge through a temporary easement, temporary eminent domain taking on the southern side of the parcel adjacent to the railroad tracks. You may also recall that last year we came before you with a special permit, a site plan application, and you approved it for a transportation maintenance terminal that was to be occupied by the MTA. That approval is under appeal by both neighbors, and some of the conditions of approval are also under appeal by my clients. That's a little bit of the background of the property. So the motor vehicle club that we are proposing is a new use. Motor vehicle storage is currently allowed by special permit in the SDLI zone, but it didn't adequately describe or include the uses that my client proposes. It contemplated strictly motor vehicle storage, but a club use would be where individuals who store their cars there could then come meet with other members of the club, check out their own cars, have events related to the auto industry or other events, such as, for example, a filming of an auto-related movie, live streaming of the Formula One race that takes place in Miami in the spring and takes place in Las Vegas in the fall, and also in other places around the world. There'd also so the storage of the vehicle space is about 84,000 square feet. Event space is also proposed, just over 20,000, where my client could have smaller events for members or for guests of members, ranging in size, generally about 100 and 150 people, to maybe an event that has 300 people. But the larger events would be the exception and not the norm. There's also about 26,000 square feet proposed just for the club membership space itself, and a small space for a lounge area where there would be a bar. So I said before, none of the vehicles are proposed to be brought to the site by common carrier, no tractor trailers. Car owners would drive into Norden, come around the northern access way, and then a entrance into the building would be created so that the cars could drive right up and into the building. I neglected to mention that present tonight on this call is Akiva Cobre. He's a representative of the owner of Norwalk Center LLC. Grant Wright, he is the project architect. And I believe Andrew Pisser, yes, he is the representative and owner of the Auto Collective. They're all on tonight in case you have any questions of them. In speaking with Mr. Baker, we decided that you wanted just a preliminary presentation, an overview, and not have, so you won't have tonight presentations by the civil engineer or the traffic engineer, both of whom have also submitted plans and reports. A little bit more information, the anticipated number of employees is about 9 to 10 full-time employees, approximately 3 to 4 part-time employees. The club would be available to members about 60 hours a week, generally Sundays from 10 in the morning to 3 in the afternoon, Monday through Thursday from noon to about 8 p.m., and then Friday and Saturdays from noon till about 11 p.m. The proposal is under review by various city departments, some of which have already sent their sign-offs today. As a matter of fact, First District Water Department issued a sign-off, and I believe Health Department has already reviewed the proposal. We're working on comments from the Department of Public Works, from Transportation, Mobility, and Parking, and Fire Department. So that is the proposal in a nutshell. I don't know if you'd like to see a brief presentation by Mr. Wright of the exterior elevations or what the interior elevation might look like. We're happy to show those to you, but we wanted to get a presentation before you so you can start thinking about the project. If you have any questions tonight, we're certainly happy to answer them. You have others to share them with staff, and we'll certainly answer those. And we look forward to having you schedule a date for a public hearing. Ms. Langalis, I see your hand up.
Oh, thank you, Attorney Suchi. I just want to make sure that I understand the structure that this application is proposing. It's the same structure that the MTA depot is going to be in?
That's correct. The MTA depot is in a different section of the building, and that was about 113,000 square feet of existing space. This is additional space that's vacant. And if you drive into the Norwalk site, the Norden site, and you take the access way that leads you to the Halstead Apartments, you continue to drive before you hit the data center, which is the large building between the Halstead Apartments and the Norden building. There's that large parking field. The corner of the Norden building that is just before the parking fields, that's generally where this car club would be proposed, that northeast corner of the building.
Okay, and so regardless of the legal appeal for the MTA, this project would not be in any of the same space as that project?
That is correct.
Okay, great. Thank you.
You're welcome. And if some of you have any desire to get a better sense of what these types of car clubs are like, you might take a ride up to Danbury. There is one adjacent to the Danbury Airport on Mary Brook Road. You can drive by it. I don't know if you'll be able to get in, but you'll see kind of what it looks like and how it functions. I'm sorry, Commissioner Wells, I interrupted you.
I was just going to ask how many members do they anticipate having?
I believe we're looking at approximately 400.
Okay, so 400 members and members and their guests can attend. Are there any limits to how many guests of a member can attend a function?
At this point, no, but I think we would be considering some caps on the maximum number of attendees at one of the larger events. The smaller events could be anywhere from 50 members and guests to about 150. That's the norm for the types of events that are proposed. The larger events, maybe 300, 350 members and guests, that would be a total. But those are numbers that we have right now. If there's concern about maximum on the larger events, we can certainly talk about what would be a reasonable cap on that number. But those are not the norm. Those are the exception on, maybe once a month, once every 2 months. The smaller events are the ones that are more frequent.
I see. Thank you.
Mhm.
And of course, everything is inside.
Yes.
JJ has her hand up.
You're
JJ?
muted, JJ.
Can't hear you, JJ. I think you're unmuted, but check the microphone. It might not be picking you up.
Nope.
No.
You can, if you have a question, you can email me and I can ask for it if you want to do that.
Okay.
Or we'll be back again. You can
Yeah, we
certainly ask us the question next time if you'd like.
And Diana, she has her hand up. Diana?
Thank you, Galen. So I'm a little bit confused what building this club would be in. As I looked at the site, there were 3 buildings. Would it be in the first or the second building?
Well, there are 3 buildings on the site. The largest building is the 600,000 square foot former Norden site. This would occupy a portion of that building in the northeast corner, about 20% of the building.
So
If
that
you-
would be the first building
The
on the
first
site?
large building. The second building
And
on the site, if you drive in toward the apartment building, that's a data
Mhm.
center, that this has no connection with that. Then there's a smaller 9,000 square foot building on the southeast section of the property. It was like a test building, and that's not part of this at all. This proposed car club would be in the large Norden building, an existing vacant space.
And the parking would be in front of it between Norden Place and the building?
Between the access way to the apartments in the back, there's a large parking lot there, and then there is also parking in front of the Norden building between Norden Place and the main structure.
Okay, and they would have access to both parking areas?
Yes.
Brian, can you
Okay,
bring
thank
the aerial up really quick? Maybe that'll help.
Liz, do you want me to open the drawing, the submitted drawing, or?
That would be fine, Grant. I'm sorry. I
No,
should have
that's
done it
fine.
before. I apologize.
No, that's all right. I'm gonna share my screen real quick and you should be able to. And everybody see that?
There we go. Okay, so Norden Place is on the far left of the screen, the western portion of the screen. If you were to come into the site from Norden Place,
Right.
you would access, there's the cursor, come around, there's an access way that then comes adjacent to the Norden Place building and another one on the northern side. The proposed car club is generally where Grant is showing the cursor in that area.
It's this section here.
There it is. On the upper floor. It's all on the interior. There are no additional expansions of the building, no additional structures proposed. It's all use of existing space. Is that better, Commissioner Lankowski? Does that help you out?
Thank you very much. Yes, that helps. Thank you.
Grant, could you just go back to the aerial one more time?
Sure.
And just so that you know, the two other buildings, the main building, the large 600,000 is where the 10 is. Where the cursor is on the right, that white building, that's the data center that's existing, that is not changing. And the smaller building on the southeastern side of the property, that's the test building, about 9,000 square feet, that there's no plan for that at this point. Does anyone have any other questions for us at this stage?
Go ahead, Chapin.
Yeah, I do have a question. If you go back to the labeled site plan, most of the labeled spaces made sense to me, but I wasn't quite sure what was intended by the hand wash area. Could you elaborate on, clarify what that is?
Sure.
Grant, could you answer that?
Sure, and Andrew may be able to chime in too, but this is, they're coming off this main access way when they enter into the building. So there's two large overhead doors here that the cars will come into the space, and they'll be wiped off before they enter the storage area to be put on the racks.
I see. Okay, so that's the entrance for the vehicles coming in, and where the vehicles could then be cleaned before being put on the racks. Is that right?
So the car storage is there, and then the main entrance to either the club space or the event space is here off of what used to be the Pepperidge Farm space. And then for the club area, there's a separate entrance as well.
Great, thank you. And then a separate question I had was, I think I had seen in the materials that there was a mention of infrequent outdoor display of vehicles. Can you provide more information about what's intended there?
Well, I guess, and Andrew Pisser can correct me, but let's just say there's going to be a Formula One simulcast. Perhaps some members will show their classic or luxury vehicle outside for a limited amount of time, but it's not that there's no intention to store vehicles outside overnight for long periods of time throughout a week. It would be a limited example for other members to come and see, or members of the public to come by and see what types of vehicles exist, and then they would go back inside in storage.
Thank you. That's helpful clarification. Those are all the questions I had.
Well, if you think of other questions, please feel free to share them with staff.
Attorney Sacchi, I looked at this several days ago, so I just don't recall. What is the maximum number of vehicles that can be accommodated indoors?
I believe the maximum number on the lifts is 420. Am I right, Andrew?
Correct, that's right.
Yep, 2 levels.
Thank you.
Sure. So if you think of anything over the next few weeks, next few days, weeks, please share them with staff. Staff is very good at getting those questions to us, and we'll respond either in writing if necessary or at the next meeting. I would like you to be able to schedule a public hearing as soon as you can. I think we'll have all of the departmental sign-offs and approvals in place prior to any hearing. The other thing I wanted to mention is members of the public who live within 100 feet of this site were notified by mail of the submission of the application, and then we'll certainly notify them in accordance with the regulations, any date and time of the public hearing, including the posting of a sign on the property.
Go ahead, Derek.
The hours of operation.
Hours of operation, generally Sunday from 10 in the morning to 3 in the afternoon, Monday through Thursday, noon to about 8, and Friday, Saturday, noon to about 11, depending upon events that may be scheduled, but that's generally the hours of operation during the week.
Well, thank you, Attorney Sacchi.
Also, would members have 24-hour access to the facility or no?
Andrew, 24 hours?
They won't have access 24 hours to the facility. Cars, if they need to check them out, will be done through a electronic means. So app will be used, the car will be requested, and then during opening hours, the car will be made available for members. But they will not have access to the facility 24 hours a day.
Thank you.
Sure.
Okay. Does anybody else have any questions of Attorney Sacchi? Okay, I don't see any, so thank you so much, Attorney Sacchi.
Thank you very much, Madam Chairwoman.
For the next matter before us, and that is 2025-18 SP Indian Hill RE LLC, 284 New Canaan Avenue. That's District 5, Block 46, Lot 76. And it's about regarding an after the fact cleaning of 1,500 square feet, which is to be restored with planting. Is anyone here representing Indian Hill RE LLC?
Good evening, Rick Costantini from FLB Law, representing the owner of the property. How are you tonight?
Good, thank you.
I also have Brian Carey from Landtech, who is our engineer, also available with us to answer any questions. Very briefly, I just want to address, because I read through the staff report, and it seems there's a little bit mess up on our end in terms of requirement. Sounds like it needs multiple special permit applications to address some of the issues here. And so there's sort of two parts to this. There's the notice of violation. Obviously, there was clear cutting of the property. The application contained the restoration plan that was approved by Inland Wetlands that we did submit. There has been a subsequent change to that through discussion with Inland Wetlands. Brian Carey from Landtech can speak in more detail, but my understanding is that they requested that some of the trees that we were proposing to plant be swapped out for different varieties. I think they wanted some evergreens. But ultimately, Inland Wetland did approve a restoration plan to restore that area. Those plans, like I said, have been submitted, but we will update them to account for the fact that different varieties of trees will be planted in that area in addition to what was already proposed. The other aspect of our application dealt with the modification to the existing special permit, seeking to swap out what was approved was an above ground detention, stormwater detention system with an underground Coltrack system. We are still working with Inland Wetland on that. We don't have any approvals from that board yet. We are working with them on that. None of the, I'll just step back. A second special permit application will be submitted to address that aspect, any modification based on that per staff requirements and per the staff report requesting that it be a separate application. We will do that. But at this point, we're still working with Inland Wetlands to determine the best course forward. We're scheduled to be before them April 22nd at the next hearing. I can let, and if you're available and you want to chime in on that, because I know you were at the last meeting, but in terms of the status of that. Brian, are you able to chime in or not?
Yeah, I was at the last meeting. I was just looking at the plan. I'm sorry. Yes. So the last meeting, we basically have until April 22nd for them to grant or deny the application. And that's pending right now.
We're happy to answer any questions that you have regarding this. Again, I apologize in advance. I understand that the staff was looking for separate special permit applications addressing two different issues. We've submitted it as a single application. That'll be corrected once we have the determination on the stormwater changes. Then we would submit a separate special permit application to address a modification of the existing special permit for that issue. Just to be clear, none of what being proposed is any sort of expansion of the contractor yard, which is what this is. It would be within the same meets and bounds that was approved initially for this site. We're not proposing to expand it in any way. I just wanted to be clear about that because I didn't want there to be any confusion regarding that point. But we're happy to answer any questions you have.
I have a question about the trees you're planting. What is the size of the trees?
I'm going to share my screen real quick. So there's two areas of the property that have been cleared beyond the limits. The first one that we have approval to restore is along the northwest boundary. This is the planting plan that was approved by the Inland Wetland Commission at their second February meeting. The size of the trees that are being planted are 6 feet. so generally 2.5-inch caliper. The change that we made at the request of the neighbors and the commission was we actually added a black spruce line along the back of the restoration area to provide evergreen screening between the adjacent neighbors who are in New Canaan and the existing contractor yard that was previously approved in 2016 and received a modification via special permit to change the stormwater system in this area. Currently, again, we had 2 violations. One was to restore this area because this was clear cut, and then there was another area where the yard was expanded here. We're still working on the revision on the restoration plan approval for this lower area and the modification to change the above ground detention to below ground detention in this area. But this plan has been approved by the Inland Wetland Commission. I don't believe it needs a special permit approval because it just is a wetland violation. And we're seeking to resolve that currently working with not only the Inland Wetland Agency, but commission staff. There's about 60, there is 65 trees that are being planted. It's about 2 for 1 for what was removed. And then there's a dense under layer of shrubs, all of wetland, upland, wetland dependent shrubs. And then the lower layer of that, there's actually a seed layer for forbs and grasses. So we're currently working on coordinating all that planting to restore that area.
Question, Steve, 2.5-inch caliper trees, 6 feet tall, awfully small. With the approval of Inland Wetlands, did they approve trees of that size? And do we have any say in establishing the size of the trees? I'd certainly like to see.
I can respond to that.
Yeah.
I'm Brian Carey, professional wetland scientist. I'm also a certified Connecticut arborist. 2.5-inch size caliper tree is your normal nursery stock. You're not going to be able to get trees much larger than that. They become more difficult to be moved and also restored. They get into an area of ball and burlap. As part of the approval through the Inland Wetlands Commission, this is following the Army Corps guideline for stem count for a restoration area. It becomes impractical to plant in an area this densely when you start getting trees that are larger than 2.5, 3-inch caliper. This is, following all best management practices for wetland restorations in accordance with the Army Corps of Engineers, but also ISI, International Society of Arboricultural Tree Sizes. And truthfully, it's just based on what's available, largest sizes that are available in bulk quantities in the nursery trade.
Yeah, Mr. Schultz, I would probably, I can check with Alexis in conservation, but I would defer to what conservation in this instance had recommended.
Would you just have a conversation with them regarding that?
Certainly.
Okay, thank you.
I think my question is, or Lou, did you have anything else?
No, that's it, Chapin. Thanks.
I think my question is also directed at staff. Procedurally, is this something where we will have the approval from Inland Wetland before we can actually take this on and start to evaluate it in a meeting?
Yeah, ideally that kind of lines up with what statute directs you to do. So we're hoping that would happen beforehand.
Great, thank you.
There any other questions?
Yeah, Galen, if I may. I think to the applicant, I'm just curious how this area came to be cleared. Was it a misunderstanding?
Yeah, there was a misunderstanding, thinking that approvals were already in place between between the applicant and a member of my staff. But that's why we're working to resolve it. The one thing too, the applicant did have prior approvals for the property. And during the period between when this was initially approved in 2016, revised in 2018, the Inland Wetland Agency actually doubled the size of their upland review area from 50 to 100 feet. So some of the work that had been done was outside and still remains outside the upland review area. But you know, it works as a functioning unit. So they are requiring a restoration of the whole area. If you can see on this, there are wetlands approximate to where some of the clearing is. This line here, if you can see it, is the 100-foot upland review area, but a lot of this area is outside of the 100-foot upland review area. So, you know, it wouldn't necessarily trigger a permit from wetlands, but it would trigger a permit from zoning, obviously, because it's outside of where the special permit allowed them to have the existing construction yard. So by addressing wetlands concerns, we're also, you know, jumping ahead of this and trying to address the violation through zoning and the special permit that would arise for the need that would arise from that.
Okay, and then one other question. I believe this business used to be by the railroad tracks in East Norwalk and Lincoln Square, and they moved to this location, relatively speaking, not that long ago. Is that right?
That's correct. As part of the state of Connecticut, as part of an eminent domain procedure, took their former property, you know, obviously for just compensation based on eminent domain, as part of the railroad train replacement in South Norwalk. And then this was the spot that the city and the state worked with the applicant to find to basically repurpose it because it was an old armory, state armory. So they basically have tried to repurpose this property to you know, fit their operations. They are a growing company. They do service Fairfield County and beyond for all the utilities. And they do have emergency operations that run out of this facility if there's a sewer or water main break. So they are trying to make the best of this. They have made some pretty substantial improvements to the actual building. And they're just looking now to really clean up and make this more of a usable yard for them based on the past history. So, you know, we're trying to accommodate their use and the neighbors' uses of their residential properties as best we can.
Thank you.
Okay. Are there any other questions? If we don't have any further questions, then I thank you for your presentation, and we will move on in the agenda.
Thank you all. Have a great night.
Thank you.
Thank you. The next item on our agenda is 2025-08R, Planning and Zoning Commission. It's a zoning regulation text amendment. And instead of reading this whole paragraph, I think I'll turn it over to staff to present the text amendments that they're.
Sure. So this is hopefully one of the last batches of zoning changes that we're going to be making for a while. So it kind of jumps all over the place within the regulations, but most of this came up from issues that staff was having with some of the wording of some regs. So the first one, this one I presented to you guys either last month or the month before. It's in regards to flood zones and what counts as the lowest floor and what type of construction can happen in the lowest floor. So I'll kind of scoot past this one. Nothing in this language has been changed from what had previously been presented to you.
Excuse me, Brian, could you make it a little bigger? The thanks. Ah,
A lot of this is really technical flood reg language, but essentially saying that the lowest floor of a residential is supposed to solely be used for storage of vehicles and be unfinished. The second change is also in regard to the flood zone. This was also presented to you. There's a couple questions that came up about what should be included in here. So this is for properties that are within the coastal AE or VE zones, and essentially requiring that they be set back from the coastal jurisdiction line rather than the mean high tide line, just because the coastal jurisdiction line is a more easily defined and measured from point as opposed to the reach of the mean high tide. One change that in the memo that was sent to you, it originally said 25 feet. We lowered this down to 15 feet. We spoke with Amelia and Alexis in our office, who are kind of some of our flood zone experts, and they were fine with that change. So this is kind of exempting certain things from being subject to this requirement, meaning that these are the things that can be built within this area. So I know one of the things that Commissioner Rowena brought up was water dependent uses. So we added that in as being exempt from not being able to be constructed in this area. But the biggest change here and why this change came up was we had folks who had an existing structure in this area, and the regulation as written essentially didn't allow them to make any changes to it. So they couldn't remodel the interior of the structure, which wasn't the intent. So this reg would give them some relief there. But one of the things that we highlighted here that we are still kind of trying to figure out was, so you have an existing house that's in this area. We will let you raise it to comply with the flood zone regulations. But one of the things that we're not sure if we should let you do is say it's a existing one-story portion of a building. We'll let you raise it to be flood zone compliant, but this reg as currently written and highlighted would not let you put a second story on top of it. And that's based on CAM language and flood zone and FEMA interpretations of not adding more living space within the flood zone. Ultimately, whether that actually impacts, it's not going to increase the amount of impervious surface. We're kind of trying to see what you think of if you have this existing one-story portion of a building, should you be able to put a second story above it, provided that it's going to be made flood compliant? That's maybe not something that you have to determine tonight, but if you want to think about that one, and then when we go to the hearing, we can discuss further.
Well, Brian, could I bring up, so I think it would be unusual for somebody to lift only a portion of a property, because if a portion is in the flood zone, maybe the other portion isn't, but if they're going to go to the trouble, they're probably going to lift the whole structure.
Right. So what this reg would say is, say that structure is only a one-story structure and it's subject to this requirement based on where it's located in the flood zone. This regulation says you can lift the whole one-story building, but it can only be a one-story building. So you can't put a second floor or 1.5 floors on top of it. You're kind of stuck with that one story.
Well, I think it would probably defeat the purpose of lifting if that was the case, because somebody would, I'm speaking residentially anyway, to go to the expense of lifting their house, would then want to, further improve the property. So I think we have to be careful that we don't, prevent it, and then it's probably not FEMA compliant, and so then it just becomes a tear down, and then it becomes land, and they can't do anything with it.
Okay. Yeah, we'll keep this in here and discuss at the hearing. And
Okay, and then also if in the substantial damage shall be located at least 15 feet landward, what if they're already non-conforming, and a lot of the older houses, say down off of Woodward Street, are maybe non-conforming in their lots because they were built before there were any zoning regs. So you wouldn't want to prevent somebody from lifting the house if the lot, if the coverage was non-conforming already.
right, yeah. So this is going to let you lift what's there.
Okay.
Not
But
necessarily.
not have to move it, right?
Right,
Because,
correct. You
Okay.
can lift, yeah, you'd be able to go straight up over what you have. Yep.
all right, that's great. Thank you.
All right, moving on. Light industrial and heavy industrial zone. This is amending the charts to add in maximum heights. So currently there's a max number of stories, but there's not a max on how tall each story can be. So we're going to put those in there. And this language, like the height, was pulled from the industrial zone study as the recommendations within that. Because of the change that we just went over with the where we're measuring from, we have to change the rear setbacks within the marine commercial zone, which currently reference mean high water, and instead reference coastal jurisdiction. So this one is it's how it's written is probably a little bit wordy, but it's specific to water course lots, which is a lot that abuts the water. So right now, the regulations treat the water as a frontage, which isn't necessarily a bad thing. So it would apply the frontage type standards along the water as well, meaning you have to have the building look a certain way along the water. But it probably doesn't need to apply to like single family and two family houses that are water course lots. So we want to restrict the zones that this applies to, and then also kind of bake in a little bit of leniency in terms of how the setbacks that apply and the amount of frontage that the building has to occupy. So for example, if you're in the CD4 zone, you need to occupy 80% of the frontage of the lot, both on the street and along the water. And then you have a maximum setback that technically would apply both ways, which is sort of confusing because we want you to put a boardwalk in. Where do you start measuring the maximum front setback from, and then building out 80% along the water seems like a high percentage. So we're kind of proposing to reduce that down, and hopefully meet everybody in the middle there.
Brian, what is lodging?
So lodging uses like hotels, motels, things like that.
Okay, thank you.
Yeah, so how would that impact, say, Hotel Zero up on Main Avenue?
So this shouldn't impact them currently, unless, well, if they are abutting the river. I'm not sure if they are.
Right, yeah, they are. It's right on the river.
Yeah, so this wouldn't impact them because they're not within one of these zones, so they'd be exempt from it. So we try to limit this to the zones that actually abut like the Norwalk Harbor.
Okay, because I mean, the Norwalk River isn't just in the harbor, and you think there's 5 Mile River, there's other rivers too.
Right. Yeah. So this will impact like Rowan Avenue Village District along 5 Mile River, and then mostly everything along Water Street.
Yeah, this language, Brian and I have been going back and forth. I expect it could see some revision at some point in time before the hearing. So.
Okay. It can be tricky.
Yeah, like my house in West Norwalk is abuts the 5 Mile River. For
Yeah, so we don't want to say like a single family house has to, have a required to look a certain way along the river. I don't think that was the intent of the reg. I think this was supposed to be more specific to our commercial areas where we kind of want buildings to look nice like for the boaters who are going by and going up to the docks.
Well, no one's boating by on the 5 Mile River, that's for sure.
This is a change to trigger site plan reviews that exceed a certain square footage. So if you have an existing building or existing use within a building and you are changing it by, taking 20,000 square feet of floor area and changing it to another use, then it has to come back to you at least for a site plan review unless it says a special permit is needed. And this is language that's taken from old regs.
Yeah, so just to clarify, right now there isn't a trigger, so we felt it was probably a good idea to have some kind of benchmark in there.
This is for Trader Vocational Schools. So we've had a couple Trader Vocational Schools reach out to us, which are smaller scale, and they'd be like an existing business who also wants to do some sort of Trader Vocational School. So for example, we had the Factory Underground reach out to us, and they want to do some sort of audio school or sound school within the existing building. So we took a look at our Trader Vocational School language, and it's sort of restrictive because I think it was mostly written for 25 Van Zant. So at the time, a lot of the language was tailored towards that parcel and kind of the dimensions of that parcel. So he said it's probably a use that's not a terrible idea in multiple locations. So we wanted to take away some of the restrictions like having the minimum lot size and making it permitted easier in more of the commercial zones. So switching it from a special permit use to either an over-the-counter if it's under that 20,000 square foot requirement that we just looked at, or it would be a site plan review if it exceeds the 20,000 square foot requirement that we looked at. This is for motor vehicle storage and indoor and outdoor storage of passenger motor vehicles, which are, it's kind of like the same use listed twice, and it's also not a great use. So we're proposing to essentially delete it as a use, and then amend the warehouse use to allow for the indoor storage of vehicles. So again, this is, if somebody has a warehouse, they'd be allowed to store vehicles within it, but having just kind of a lot that you store cars on outside kind of isn't necessarily a great use. So we were that's why we were proposing to delete that as a use. And then adding in those limitations for warehouse use specifically, which is only allowed in the, this should actually switch. This is mislabeled, but that would be the LI and the HI. Actually gonna fix that.
Would that affect the application that was just presented to us this evening?
No, because they are proposing to do a new use called the Car Club, and then their entire use would be within that new use that they're proposing.
Okay, thanks.
And then with that, adding warehousing as an accessory use, because there are uses like mostly limited to like boutique manufacturing or light manufacturing that have some sort of warehousing component to it. So we'd put that in as an accessory use so that those certain businesses would be able to have some sort of warehousing component accessory to their primary use. Now I'll let Steve talk about workforce housing.
Sure. So out of the affordable housing plan, there were, and we're starting to like hit on some of the low hanging fruit that came out of the plan. There was one segment that the consultant identified that wasn't being met with their current workforce housing regulations, which was that segment of population that is over 80% SMI. So there's two regulations we're proposing. One of them I think is pretty straightforward, and the second one is maybe a little bit, might warrant a little more discussion. So the first one basically is saying, in a nutshell, if you end up, you're in a workforce unit and you're going to recertify at the required time, and you happen to get a raise, for example, and so you're making more money, you're no longer below 80% SMI, say you're at 85% SMI. We're saying you don't have to leave that unit. You're allowed to stay in that unit provided you don't exceed 90% SMI. The one caveat that we need to understand is that technically at that point in time, that unit won't count towards the city's affordable housing requirements. So we, theoretically could dip below that. Right now we're at like 14% or so. So we're saying, all right, you can do that, but at that time, the city has to be at least at 12%. So we're kind of putting in a little bit of a buffer to make sure we don't dip down too much. We don't think there's going to be that many people that are in this kind of scenario, but there's probably going to be a few. But so we think this is a way to allow them to actually make a little bit more money, save a little bit of money on rent, and it doesn't really do any damage to the city's overall percent of affordability. So that's one recommendation that we came up with. The second one is something a little different, where right now we require 10% of the units at either 80% or 60% SMI, and there's some different things they have to do if they choose one path or the other. This is allowing for a slight 5% density bump if they deed restrict those additional units between 80 and 90% SMI. Those units, again, won't count towards the city's overall affordability requirements, but they do provide a little bit of extra housing that's affordable to us, another segment that's not kind of getting represented with our existing workforce housing. In addition to these two, it's not in this packet. It's going to take a little longer to develop. I'm looking at trying to do something with some other kind of density bonuses for hitting at some more deeply affordable units. We had something in the old regs no one ever utilized just because it was kind of clunky. So I'm starting to look at what other towns are doing to see if I can come up with a better model. But that one, like I said, is going to take a little bit more time. These two here, I think, were a little more on the low-hanging fruit. Again, the first one, which was proposed at number 14, I think addresses a very specific niche, where number 15 is also getting at that same cohort, but also looking at it from an incentive standpoint to add additional units.
So
Steve, what is at the current state SMI, what is the difference between 80% and 90%, roughly, in dollars?
I don't want to tell you the wrong amount. I can email that out tomorrow if that's okay. I have a chart. I just don't have it in front of me.
Okay, thank you.
Steve, could you answer how many units of housing is that? How many units are we talking about? And then is it your department, P&Z, that keeps the data and enforces this?
I'm not sure what you're asking in the first part.
Oh, sorry. How many apartments or units of housing are we, how many units makes up the city's 14%? So a few, how many would we need to have a change in the status of the person and either have them move out to keep it still affordable, roughly,
I can get you that number tomorrow as well. I don't have the exact number. I did, Michelle Andriski, who kind of she kind of runs and monitors the workforce, the workforce housing program. She's been looking at, I asked her, said, how many, like if we did, if we did enact this, how many households are we talking about? Sorry. She didn't think there was going to be that many based on the sample of the income requirements that she's looked at for like the past users. But I can get you the firm numbers on the complete, SMI breakdowns, as well as the total number of units we have in the program and what that percent change would be.
Thank you. And Steve, your department enforces all of this?
Correct. We monitor and enforce the workforce housing provisions. So we look at all the paperwork that comes in, monitor the reporting requirements, make sure they're done by certain deadlines, and then we have to forward all that up to the state, who also takes another look at that.
Okay, thanks.
Steve, the more deeply affordable side of it that you're still working through, are we talking about 40 to 60%?
Possibly. We haven't set like a certain number yet. I mean, there could be could be 40 to 60. It could be, we could also look at different brackets so you could go 70 to 50 and then 50 to 30. I haven't quite figured out what could work yet, but all options are on the table at this point.
Okay, thank you.
Oh, in
next-
this one, I'll just hit this one too. So right now, the existing language you can see here is this basically notice requirements. We're basically asking people to do two different types of mailing. If you're familiar with ever done certified mail, there's the green cards, and then there's that's certified mail. Then there's also certificate of mailing, which is what the statute says you have to do. And certificate of mailing is what we're recommending, because basically what it is like if you're doing a large mailing for like a special permit application, you list all the properties on, that whatever can fit on the sheet they provide. And it's date stamped on the date that you mail it. So it's proof that you mailed to 50 Smith Street on this date. So that's how we verify that they met their mailing requirements at least 10 days prior to the scheduled hearing. Right now, we're kind of saying you have to do two different things, which doesn't make sense. This one is just the simpler option, which is consistent with statute.
And then last, I think this is last, we went over this a month or two ago. This is just adding in definitions. This is for unfinished area and finished habitable area, which are pulled from FEMA. So these would apply to flood zones. And then amending the story definition to reference the unfinished area definition, and also lowest floor. Because again, all of these ones kind of mostly pertain to the flood zone and what counts as a story, what doesn't count as a story, and then the construction that can happen within those areas. And then last, this was just to modify the motor vehicle body shop, because we're removing, or at least proposing to remove, the storage of motor vehicles. There are uses like the other two motor vehicle related uses that we have within the definition state that there's incidental outdoor storage of vehicles, which would be expected if you're dropping your car off to get fixed, that they would store it there. So this would just be updating that definition to include incidental storage of motor vehicles for a motor vehicle body shop. And that's everything here.
Okay, great, thank you. The next item on our agenda is discussion. Does anyone have anything they need to discuss?
Probably could have taken that one off because you have your comments, your commissioners too, so.
Right. So let's do the acceptance of minutes of the regular meeting of March 19th, 2025. All those,
I'd like to make a modification beforehand, or I could move for modification. I saw at the very beginning, it said that I called the meeting to order, but I believe you did, Galen. So I wanted to just call it out as a quick fix to the minutes. But happy to move to approve, yeah.
okay. So you
I'll
moved
second as amended.
that change. All those in favor of accepting the minutes with the change suggested by Chapin, raise your hand. I have to move along. That looks like it.
Because I wasn't there.
I'm abstaining. I wasn't there.
Okay, good. Okay, so the motion passes. I have to change it to gallery view so I can see everybody at once. All right, then the next item is comments of the director. Do you have any comments, additional comments, Steve?
Sure, just a couple of quick notes as we discuss next Wednesday, which I'm going to shoot for 6:30 and we'll be done before 7:30, I think, up at Gray Barn. So I'll send out an agenda and all the specifics on that, following up what we were talking about earlier. The meeting will be I'm trying to keep it as tight as possible, where I would recommend, if you can read through the applicant's narrative, read through what they're proposing for what they'll like accept for conditions. And then if you want to get me questions ahead of time so I can point out things, the idea is just being to really orientate you on the site to what activities are occurring where, how they process things, where the neighbors are in conjunction to the different activities and uses on the property. We had a conversation earlier today with Mario, Matt, and also Mark Brantz, who you remember from the zoning update, who's kind of one of the land use attorney gurus in the state. And we were talking about site visits, and he said it's really important not to have any conversations amongst yourselves with the public, with the applicant or anything, because A, you can't record it because it's outdoors, nothing gets recorded. It's just too easy to have sidebar conversations. So that's why we're really just limiting it to here's this, here's that, here's what they're proposing to do here. And then when we're in the actual public hearing, then circle back on specific questions related to activities they're doing and what the impacts may or may not be. And then,
Can you resend that, Steve? The application, can you resend that to us?
I'll send out the workforce housing information you requested and the link to that application so you have that directly.
And thank you. And could you also include the applicant for the property just to the north? So, the one that I mean?
The one you guys approved? Is that?
Yes.
Okay, sure. I can do
Thank
that.
you.
Steve, are you guys going to be going like into the barn or into the buildings, or is it just walking around on the property?
I think we'll go into the barn because the actual inn is not really subject to the application. It's kind of related and integral, but I don't think we'll be going inside there. We'll probably be just parking at the barn site. The barn has big doors, so it's probably going to be wide open. Hopefully the weather is nice, but we'll deal with that if it's not.
Okay. I won't be able to make it, but if it's possible, if I'm able to just stop by over the weekend, and walk around the public areas, I've been over there. I'll try to do that.
Yeah, and if you want, we can arrange staff to meet you out there at a separate time to kind of show you what we talked about with them. We can figure that out too.
Okay, thank you so much.
Yep. And then the following week is your normal meeting. And that one, just as a reminder, is going to be in person. There's a few applications. I don't think it's going to be a super long meeting, but that's going to be in person at City Hall. And then you have 2 weeks with no meetings, so that's good.
Okay. Okay, any comments of commissioners? No comments of commissioners? Okay, well then I'll entertain a motion to adjourn. Chapin motion moves to adjourn.
I'll second.
Okay. Darius seconds. All those in favor?
Aye.
Yes. Okay. Any opposed? Okay, we are adjourned. Thank you very much.
Have a good night, everybody.
Have a good evening.
Thank you.